Ms. Mosby, you can get the jury. Everyone, please stand as the jury comes into the courtroom. You may be seated. Jefferson County Court, Item number 2 is back in session. The court is in session and calls number 23-CCCR 0744. Case is style of State of Texas versus Kiana LaShawn Bailey. Let the record reflect that Ms. Bailey is present in court with her attorney, Attorney Bryce Kimbler. Let the record also reflect that the state is present with Assistant Criminal District Attorneys, Attorney Farrah Nixon and Attorney Fred Berner. Let the record reflect that the jury is now present and seated in the courtroom. State, are you ready?
Yes, Your Honor, state ready.
And defense, are you ready?
Ready.
Okay. Mr. Vernon, would you please call your next witness?
Yes, Your Honor, the state calls Ms. Madrika Lee to the stand.
Madrika Lee.
We're going to see closer.
That will be good. Ms. Lee, would you please raise your right hand? Do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
You may put your hand down. You can take the witness stand. You could adjust the chair and the mic.
okay.
Vernon, you may move forward.
Thank you. Would you please state your name for the record?
My name is Madrika Marie Lee.
Would you please spell that?
My first name is spelled M-E-D, Rickka. My middle name is Marie, and my last name is Lee.
Very good. How you feeling today?
I'm nervous.
A little nervous? That's all right. Don't,
Mr. Brown, would you ask Ms. Lee to speak up or sit closer to the microphone?
Okay.
there you go. All right. We need to re-ask for the record or? Do re-ask?
No, no, he heard it.
Yeah, I caught that.
Yeah, I think some of the jurors was having some problems.
So you said you're a little nervous?
Yes.
Don't worry about that. We're all here to listen to your story and, ladies and gentlemen of the jury, people are here to listen, here to help. Will you share with us a little bit about your, educational background?
So I hold a degree in applied arts and science from Memorial University, along with a minor in anthropology and a minor in family consumer science. I also have participated in a women's entrepreneurship program from Cornell University. I also hold a license certification from the American Association of Family Consumer Science that allows me to be a family consumer scientist and also allows me to teach 40 different family consumer science classes in the state of Texas, which is known as home ec.
Okay.
And currently, I'm going to be pursuing my master's of business administration this upcoming fall.
Do you know where you want to go?
I'm going to the, I prefer to keep that private, but
Alright.
I have been accepted to grad school.
Congratulations. So are you currently, employed, Mrs. Lee?
Yes, I work in the educational field.
Do you have any children, Mrs. Lee?
Yes, I have one child. He's 20 years old. He's on the autism spectrum. He's also diagnosed with an intellectual delay and speech delay. He graduated high school in 2024 with honors. He and also two endorsements from the state of Texas on his diploma. He's also was active in Future Farmers America and
Okay, objections to that.
So we'll move forward. How's your living arrangement? Does he live with you?
he lives with me and his grandmother.
Okay, his grandmother also lives with you?
Yeah,
Let me ask you, how old were you on the day of the assault? That'd be 4/16/2023.
I would have been 42. I turned 45 this upcoming summer.
Do you feel it's important to testify today?
Oh, I feel it's very important.
Why do you feel that way?
Because a crime was committed against me and there should be some type of consequence. I'm still feeling the impact of that crime, and I want my story to be solved.
With whom were you employed on the day of the assault?
I was employed with a app that allows for you to customers to get their groceries and have them delivered to their home without them leaving.
And so you supported them by picking up groceries from the grocery store and delivering that to homes for people?
Yes, sir.
Okay. What was your reason for being in HEB on the day of the assault?
I had took an assignment to shop for a customer and pick up their food and deliver to their home.
So you were in the scope of your employment, you were working on the day that you were assaulted?
Yes, sir.
Okay, so we're gonna talk a little more about that. So, while you were there, after the assault occurred, did Officer Wilkes talk to you about being trespassed from HEB or?
Yes, sir.
And how did how did that start? What did you say?
She had informed me I had been trespassed against HEB, and I explained to her that I was not the cause of the altercation, so she told me to wait.
And did she come back out and speak to you after that? And what did you come to learn after she came?
Once she came back and spoke to me, she told me
Objection sustained.
Did you come to learn whether you were trespassed or not?
I was not trespassed.
All right, so let's dive a little deeper. Do you recall what aisle you were on in HEB when you first interacted with the defendant?
Aisle 7, which is the spice aisle and the dry goods aisle.
Okay, okay. Permission to publish, Your Honor?
Yes, you may publish.
If you can pause it there. Ms. Lee, is that yourself here?
Yes, sir.
Is this the spice aisle?
Yes, sir.
And which aisle number is that?
7.
Okay. Go ahead and play it fair. You pause it there. Is this the defendant here standing next to you?
Yes, sir.
Okay. And what was her demeanor like when you first approached her and started speaking with
It was, she was trying to recognize who I was. She was calling me by my name.
him?
She said, Madrika, and I turned around and
Wait, wait, wait. Is that when she called your name?
yes,
Look at there. Permission to publish states 2.
Okay, you have permission.
Excuse me, Your Honor, states 3.
It's already in evidence.
Oh, that right there. Is this you here, Ms. Lee?
yes, sir.
Which aisle are you on now?
I'm on aisle 38.
Now, you had just finished speaking with the defendant on aisle 7. What had you done just before getting to this aisle here?
I had spoke to Miss Bailey, and after the conversation, I continued to shop in the store.
Okay, and when you and the defendant were on aisle 7, what did you say to the defendant to disengage from the conversation?
I had made her aware, she had brought to my attention about a family member. I made her aware that I had no connection to that. I would be not getting involved in that. So that was the extent of the conversation regarding that.
Okay, so you informed her while you guys were on aisle 7 that you, whatever it was she was trying to discuss, you were not getting involved, is that right?
Yes, sir.
Okay, and you proceeded then to aisle 38.
No, I had went to different aisles of the store. 38 was the last aisle I went down.
Okay, so this is the last aisle you went down.
Yes,
All right.
sir.
Fair, you play.
She wants to be. Sure. What to what?
Yeah.
Oh, right there. Now, Mrs. Lee, who is that walking behind you, if you know?
That is Kim Davis.
Ms. Kiana, that is the defendant.
Yes, sir.
Okay. Is the defendant present in the room today?
Yes, she is.
Would you recognize her if you saw her?
Yeah,
Could you please point her out and identify one article of clothing that she's wearing?
she's wearing a white blouse with a black bone in the front.
Could you point to her if you see her?
Yeah,
Go ahead.
she's right there.
Your Honor, at this time, please allow the record to reflect that the witness has identified the defendant.
The record will reflect that the witness has identified the defendant. You may proceed.
Thank you. When she approached you here the second time, did the defendant say to you what she wanted or wanted to speak with you about this second time?
Yeah,
What was that?
she was asking, was I on the phone, I was playing if I wasn't, she needed to get in contact with her.
And to which you responded,
I think, well, no, I'm not on the phone with her.
go ahead and play it fair. Hold that right there, fair, please. When you held up your phone to her, what were you doing?
I was holding up my phone, I was holding up my phone because I was on the phone with my mother, and my mother had heard me speaking to her, and my mother requested to speak to her. So I put my mom on speakerphone, and so then held it up for her to speak.
And the defendant has to speak to your sister,
Right,
but you on the phone with your mother.
yes, sir.
And why did you hold that phone up like that to show her to step forward? Why'd you do that?
I was gonna allow my mom to speak with her, my mom had requested to speak with her.
Okay. Now here, Fair, if you can rewind 10 seconds, get back, and play from there. Okay, pause that there. How did you feel when the defendant stepped to you like that, and pointed at you? How'd you feel?
Right,
Threatened?
yeah.
Mm-hmm. Now, at which point she appears to put launch her hand in your face,
Her first point of contact was she hit me
hit you where?
in my face,
And with which part of her body?
her hand,
Did that hurt?
yes.
Fair, if you please, play and pause right there. Where's her hand on you right now? Where's her hand located on your body?
It's on one, holding one of my hands,
She's holding one of your hands
my
there?
arm, yes.
Okay. Now, at this point, have you punched her or hit her?
No, I haven't did anything to her.
Has she already punched you in the face?
Yeah, she's hit me in my face, but not a punch.
What did she hit you? Was it a fist? Was it two
It
fingers?
was an open hand, she did like this.
Pushed your head back.
Right,
So, but
right.
she struck you with her hand.
Yes,
Okay. And you said that hurt. You felt pain, is that correct? Okay. And now she's holding on to your arm.
yes.
Go ahead and play that, Farrah. Okay, pause that and rewind it 10 seconds, please. Play. And pause right there. Why did you then lunge at her when she had her hand holding whatever part of your body? Why did you lunge? What were you feeling that made you do that?
I felt pregnant is about to get worse.
Mm-hmm. And did it get worse?
Oh, yes,
And so at which point she was holding you and you lunged forward. You
Yes,
did that
sir.
because,
because I was pregnant, she was holding me, she was touching me without my permission.
Okay.
In an aggressive manner.
and this is after she already
Yes, sir.
struck you in the face.
Yes, sir.
Go ahead and play it, Farrell. Pause that, Farrell. Now, have you, since that one lunge and y'all fell to the ground, have you thrown any more punches that you've seen?
Can you replay it, please?
Sure. Say that. Pause it, Farrell. You- Did you see yourself throwing any more
I
punches?
finished, I made a strike to her face.
You made one punch straight to her face, right? You wouldn't happen to keep counting how many times the
No,
defendant
I
punched
did
you,
not
did
count
you?
to keep count of punches.
Was it more, did it look like more than three?
No.
I'm speaking to the defendant, how many times she was punching you.
Oh, way more than three.
Okay. But you managed to get one good lick on her.
Yes, sir.
Okay. And at which point, did you grab something off the shelf?
Yes,
What did you grab?
I grabbed, a religious, prayer candle.
And why did you do that?
I was fearing for my life and I wanted to, help stop the fight to disarm her from hitting me.
Did that work out for you?
No.
Okay. Briefly, I want to go back before the interaction started. Were there some words exchanged, some not so pleasant words exchanged between you and the defendant before it went, before it got,
Yes, sir.
what were those words? What happened?
She had said some derogatory, name about my nephew.
What did she say?
She had called him a faggot.
She called your nephew a faggot.
Yes.
How'd that make you feel?
Awful. It was heartbreaking that she's speaking, on the child in that manner.
Did you say something back to her?
Yes,
What did you say to her?
I said, that's your nasty ass son.
Okay. And had she hit you at this point already or struck you in the face already?
She hit me in the face once I said that.
Once you said that, that's what triggered.
That's what started. the
Okay.
whole ordeal.
Okay. Were you physically harmed as a result of the fight?
Yes,
I'm showing you what's marked as State's Exhibit 5, 6, 7, and 8. Do you recognize these photos?
yes.
What are they?
It's a mark to my, hand,
What type of mark to your hand?
a scratch.
Okay.
And then there's a busted lip,
Okay.
scratching in my eye. Then I don't recognize it. I know I'm having head pain.
Does there appear to be a bulge here?
Yes, I'm swollen in the forehead, yeah.
Did you go to the doctor's office at all?
Yes, I went to the emergency room after this. Yeah.
How soon after the incident did you go
It
to?
was about an hour, I had to go home first. And get a transfer my sister brought me.
Which hospital did you go to?
At the time, it was, Medical Center Southeast Texas that's located on Holland.
Are you aware of when the doctor examined you, are you aware of what you asked to be treated for? Do you recall?
I had one of had been assaulted.
And do you know any abnormalities or impacts or any harm that the doctor would have specifically referenced during treatment?
He had gave me like a package that explained about when you have an altercation. And I explained to him, feeling swollen, pain in my head. They also checked to see if I had any concussion.
Specifically, any shallow wounds? Did they notice anything about your face?
No,
Okay. No or not that you can recall or what?
okay, can't recall.
Okay.
Sorry.
So you're having trouble remembering?
Yes,
Okay. If I showed you a picture of the report, would it help you?
yes.
You can take a look at this and just, don't read from it, but just once you're done, just take your time and look up at me when you finish. Okay, but when you went to that doctor, what type of pain or whatnot, what was she looking at on your physical body that may have been injured?
They was focused on my head and my face.
Okay. And she noticed any bruising or scarring? With no type, did she?
No, they did not notice.
Okay. Okay. And we're gonna, I wanna make sure you're sure about your visit here. Do you recall if there was okay, so take a look at this and we, just report. There, and tell me. Okay. I know it's complicated, but I'm gonna ask permission here, but do you know what a hematoma is?
No, sir, not aware.
Look at
It
this
was
photo
right
here.
here. I'm assuming it would be my forehead area.
So a hematoma, uh, did you have pain in specific areas on your body, on your upper body?
Yes,
Where?
in my neck and my head, my face area.
Okay, okay. Yeah, that's good enough.
Okay,
Thank you so much.
okay.
That's the witness, John.
Okay, let's, we'll take a 5-minute break and then we'll, start back with the cross examination. Everyone, please stand as you're in the courtroom.
I said that'll help y'all on DWI.
Yeah.
I need to get that the third. You can just send it to me. Okay, you can get the jury. Everyone please stand as the jury. You may be seated. Jefferson County Court 11-2 is back in session. The court is in session and calls number 23-CCCR 0744, case of style of state of Texas versus Kiana LaShawn Bailey. Let the record reflect that Ms. Bailey is present in court with her attorney, Attorney Ralph Kimmer. State is present with Assistant Criminal District Attorneys, Attorney Fred Vernon, and Attorney Farrah Nixon. Let the record also reflect that the jury is now present and seated in the courtroom. The state has passed the witness. Mr. Kimmer, the witness is yours. You may proceed.
Thank you. Afternoon, Ms. Lee.
Good afternoon.
We've never spoken before, but I recall, have we?
No, we have not.
Okay. You want me to approach?
Yes.
So we want to direct your attention to the diagram that's immediately behind you. If you turn it. My favorite present to you is, being represented by the district attorney's office, that if this is you, CWD complaining witness.
Yes, sir.
The stick figure to the right, the stick figure to the picture you is labeled Anita.
Yes, sir.
Would that be your sister,
That's my sister.
full sister?
Yes, full sister.
How many children does Anita have?
And he has 3 children.
And if you would, I'll let you, you're probably more adept at writing on boards than I am. If you would, just maybe beneath her, if you could put a list in and just do it vertically with from oldest to youngest. So the oldest one's name is,
The oldest is Max.
all right,
The middle child is Madeline. And the youngest is Mellow.
and what were Max and Madeline's ages back in 2023?
I believe they were maybe 8 or 9 or 9 or 10.
So in that range, 8 to 10?
Yes, under the age of 10.
Yes, ma'am. And if I represent to you that the stick figure depicted here with the D underneath depicts the defendant, Kiana Bailey, do you know if she has a child?
Yes.
And if you would try to depict that on the chart. And do you know the name of the child?
I do not know the name.
Or the age?
No,
What about the sex?
he's a male.
What? But and do you know is he younger or older than Max and now?
He's younger.
Up until this incident at HEB, had you had any contact with Kiana Bailey?
No.
Family meetings or did you?
No, I haven't seen her since she was a juvenile.
Okay, what was the last time you had seen her before HEB?
I cannot recall. It's been so long.
You said a juvenile, I would take that to mean somewhere between 12 and 16, maybe?
Probably so. I was probably classified as under the age of 18.
So it would have been a family event or something like that, or what would have been the context?
I really can't recall the last time I seen his family.
So you hadn't maintained a close relationship or even a familiar relationship with her throughout the years, is that?
No, sir.
Are you familiar with what the incident, or if any, if there was an incident at issue between Kiana Bailey and your sister Anita was at the time, this incident?
It was a family member between the children.
What had happened?
Objection, Your Honor. It's outside the scope of the direct examination.
Well, it's cross-examination.
This cross is outside the scope of the direct.
Well, I think this, it's been raised that there was an issue and it's contextual of what occurred with the fight, what was said, so I could. What was, maybe I could rephrase. What did she ask you about? What was Ms. Bailey asking you about?
Asking me to get her in contact with my sister.
Why?
Cause she had been trying to contact her and my sister hadn't, spoken with her.
Do you know why she was trying to contact your
It
sister?
was regarding a family member that occurred.
What?
A family matter.
What was the family matter?
It was regarding her two children, her child and my niece and nephew.
Madeline and Max.
Yes, sir.
And had there been an allegation or at least a concern that there was some sort of sexual impropriety or something to do with when they were together, something had happened?
Yes,
And you were aware of that, or did you have knowledge of that?
yes, sir.
So you knew what Miss Bailey was talking about, is that right? You were
Yeah.
aware of it? And am I correct in understanding that you indicated to her, I'm not involved, I don't want to talk, just
Correct.
leave me out of it, right?
Yes,
And that's the first interaction that we see between the two of you?
yes, sir.
And then how long would you estimate the time, the elapsed time between that first incident and then the incident we see here depicted on aisle 38? How much time elapsed?
I would say 10 to 15 minutes.
And during that 10 or 15 minute time, it's not your testimony that she was somehow stalking you throughout the store or following you or anything like that, or what?
We passed each other in the store, our shifts in the night. We did pass each other.
Okay.
No, there was no contact or, conversation made in that path.
So maybe going down rows in the opposite direction like that,
Yes,
and
sir.
no contact, right?
Yes, sir.
So this particular incident here on aisle 38, we've seen that, the video of it. Did she say anything to you, or what was the exchange, the verbal exchange?
I was walking, headed towards to check out, and she, came up to me saying, if you're on the phone with your sister, I need to get in contact with her, I want to speak with her.
Okay, so then so the checkout would be
Straight ahead.
this way. If you're on, then you were on your phone, is that right?
Correct.
Yes, see, John?
Yeah.
Okay. But you were on the phone, but just not with your sister, right?
Yes, correct.
And would you say that she approached you in a hostile manner or belligerent manner, or what was her manner in which she asked you that
It
question?
was hostile.
Was it her voice raised, or what was her tone that would lead you to infer that she was being hostile?
It was raised.
So it was above a normal tone,
Yes,
something above what I'm speaking to you now in?
yes, it wasn't screaming.
And she was requesting that she wanted to speak to your sister,
Right.
being
correct.
Anita, is that right?
Correct.
And was it your conclusion that she wanted to speak with Anita about the alleged incident between her child and Anita's two children?
Correct.
Perhaps to resolve that or have some sort of understanding or to discuss it?
Okay.
Uh, had you been on the phone or were you on your phone with your mother regarding Kiana or anything about Kiana, or was it another matter?
During that phone call, my mom had called me to check up on me. I didn't call my mom, she called to check up on me. I just happened to say, oh, hey, I seen Kiana in the store.
Okay. And
And then told her she had wanted to speak to me. Just saying that we was discussing other things.
and is that when Ms. Bailey approached you?
This is going throughout the store a long time, because the phone call when my mom starts in another section of the store.
And she had been on the phone for a
Yes, I
while.
had been on the phone with her.
Had Ms. Bailey passed you at any point while you were on the phone before or
I
not?
can't recall.
But did it appear to you that she was approaching you this time because you were on the phone?
I couldn't see, she came up from the side of me, so I don't know what her intentions were.
But the words to you were, is that I need to speak with Anita, or something to do with the phone, right?
Yes.
And what did you tell her?
I say, I'm not on the phone with Anita.
And what was her response?
I can't recall.
Well, we see, and again, what's depicted in the video, that you're holding the phone out
Right.
towards her.
Yes,
Is that right?
because my mom heard me speaking to her, and my mom asked, can you speak to her? So I put on, my mom wants to speak to Kiana, so I put on the, speakerphone.
Well, before that happened, I'm interested in what was the conversation between you and Kiana before that occurred. You had mentioned that she had said something about speaking disparagingly of one of your sister's children using a
No,
pejorative term.
before I put my mom on the speakerphone, she was requesting to talk to Anita.
Right.
Right.
When was the comment allegedly made by the defendant directed at Anita's?
The comment made by Ms. Bailey was made after I put my mom on the speakerphone.
After you were holding it up?
Yes, after I put my mom on the speakerphone.
Was there anything that precipitated that, or she just said that out of the blue? Or
She just escalated.
just blurted it out?
Yes.
Was she directing that comment to your mother or to you? Or
I don't know who it was directed towards.
And when you state that she said that, is that when you stepped towards her?
Step towards a win.
We see you step toward her in the video, right? Do you recall that?
No, I'll have to read the video before.
Should just put it, I mean, if we could pull it back, maybe.
When I'm stepping forward with the cell phone?
Yes, ma'am. If we say, if you look right, just take a look right there where you step forward, see that? And then she comes forward to you. Is that when that interchange about the children occurred?
Yes.
Okay, so we could round it up. So right here, what was the conversation going on right here? The best as you recall, I understand it's been 3 years.
Yes, I have my mom on speakerphone and she's, telling me she doesn't wanna talk to her, and then she starts getting, aggressive and says something derogatory about my nephew.
Right here, this point, right?
Yes, and then,
All right, and then let's play it. Okay. You're talking, and you step forward and you're holding the phone, and then she comes at you. Right?
mm-hmm,
And what are y'all saying right now?
I can't recall.
And then you go at her, right?
Mhm.
Then you go at her, right?
After she hits me in my face.
Well, you said, did she hit you or did she shove you?
Push me in my face.
Push.
Yes, hits me.
Okay. And here we see you all tussling on the floor a little bit, fighting. You're slipping there a little bit on the item of clothing. You get her down on top of her, right? Do you agree with all that?
Yes, sir.
Get a punch in there. Are y'all talking or saying anything to each other here?
I don't recall. I remember having a conversation during that time.
She kind of gets away from you, gets up, gets to her feet, and she hits you there a couple times. You got her by the hair, I guess, right there. Her head's down. Is that right? Was that right?
Yeah.
Yeah. Got you by the hair. Got her. Okay, is that when you get the candle? Oh, yeah, stop it right there. Okay, stop. That's when you grab the candle, is that right? Now approach now.
Yes.
You get this marked as defense 1. Ms. Lynn Haney, what's been marked, is defense exhibit 1. I represent the, purchased that at HEB over lunch at the one in Port Hoffman on 347, 365. Does that appear to be the same or similar to the candle that you employed or we see you employing in stage 1? We'll take a look at that.
Yes.
If you could, I want you to make sure the weight and everything. About the same weight, everything appears to be the same,
Yes, it looks like the similar candle.
same can. All right, maybe has a different, the one had a different picture on it.
I did not know, I wasn't
Right.
paying attention to that.
But as far as, when I say the same or similar, I'm not referring to the depiction, the visual depiction on it, but just the
Before they,
dimensions,
towards the encasing, yeah.
and the casing and everything. else, right? Your Honor, I'd offer defense one as demonstrative evidence. And I'll show it to Mr. Ryan.
I'd like to, board our.
Okay, you put that up.
Mrs. Lee. Are you aware that these candles come in different glass thicknesses?
Yes,
And, are you aware of all the different ranges that these glass thicknesses come in?
yes, I'm familiar, they're known as 7-day candles, 3-day candles, 14-day candles, yes.
And, the particular type of candle sold at, HEB that you grabbed there, the defense had asked you a few times what the words were being exchanged. At that time, you said that you couldn't recall. Is that correct?
During the time that we're fighting,
So how is it then that you're able to recall the gauge and thickness of a candle if you couldn't recall anything else at that time?
yes, sir. I don't know what the thickness was, but it was similar to that candle.
It was similar.
Yes, it's similar, but I don't know what the thickness or the circumference was. I just grabbed the candle.
Okay, so and there's probably a bunch of types of candles on those.
Yeah, there's a several different candles.
But you said you're not sure. It's maybe similar, but you're not sure.
Maybe
You're not familiar with all the
similar, yeah.
thickness and gauges. You know, at this time, the state's gonna object to this being admitted because she's not certain that this candle is similar or exactly identical to the one that she.
I'm not offering as identical, it testified it was the same or similar, so that's how I'm offering, it's demonstrative evidence, same or similar as the item she employed, I think that's what she testified to.
Then I would have to object because it's irrelevant. If we don't know if this is the exact structure of the candle that she used, can't use the demonstrative to show that this is what she was struck with.
The jury can attach what weight to it, they can, Your Honor, it's just demonstrative, she testified it's the same or similar, so that's being offered as demonstrative evidence of what was employed by her in the aisle there that we see in the video.
Your Honor, that's an insufficient predicate and the state's gonna object to it.
Does do we know if it's fairly accurately represent the objects of the model?
You said it was the same or similar, Your Honor, that wasn't the exact question.
I mean, you can ask her,
What was the question?
She said I asked her,
does
she
it
said,
fairly accurately represent the object that you purported to be?
Okay.
Your Honor, she said she doesn't know the exact size of that candle versus the other candles. She said she wasn't sure.
I don't know that it has to be exact, it's just fairly inaccurately represent what it purports to be, or what purports to be. Does it fairly inaccurately represent what it purports to be in the video?
I can't tell from the video.
You don't remember?
Everything's gone so fast. I just grabbed anything to the deed.
So you don't remember whether this is the same or similar? Or fairly inaccurately represent what
It's
you use?
similar, it's similar. But not the same.
Well, it would have a different picture.
Unfortunately, I was not looking at the image of what's on candle.
Your Honor, she's already asked and answered.
Okay, objections to say. Okay.
You hit her with a glass candle, right?
Correct.
Did it break?
I don't know.
How many times did you hit her with it?
I was not counting.
And just to be clear, Ms. Bailey didn't employ any type of weapon or any type of object during the course of the fight, is that right?
No,
Just hands.
okay, correct.
Fight gets broken up, you talk to the police. And we've heard what happens after that, right?
Yes, sir.
You filed a civil suit against Ms. Bailey over this, correct?
Correct.
And what happened on that civil suit?
I won the suit, but I wasn't awarded anything.
Okay, you're saying that you won or she won, or was this the
It
one?
was a wash. He won, I won, I wasn't awarded anything.
So neither one really won, it was,
Correct.
That was, I guess it was downstairs in Justice of the Peace, Doyle's Court.
Naomi Dole's court,
Yes, ma'am.
correct.
You had any contact with Ms. Bailey since this or not?
The last time I seen her is maybe April or May. I saw her at Walmart.
Okay, no problems,
No,
so no family get-togethers or anything like
no
that?
family get-togethers, no barbecues, no family reunions, no Christmases, no any type of, family events that people normally, attend when you have, cohesiveness in your family.
And I passed with Sharon.
Yeah. Mr. Burner?
Mrs. Lee, just a few more questions for you. Sarah, could you rewind that back to when, it first struck, Mrs. Lee? Pause it right there. And I don't think Mrs. Lee has stepped forward yet. Play it. I want to capture both. All right, pause it right there. So, Mrs. Lee, you testified earlier that your reason for stepping forward was,
I'm just like, reaching the phone out so my mother could speak.
but you weren't angry or trying to,
I was not upset at all. I'm just waiting for this to end so I can continue on to the checkout because I was on a time schedule.
um. And who struck who first?
Miss Bailey hit me first
And where she hit you?
in the face with her hand.
Um, now going back to, the incident with the family. Did you have any involvement with that? Were you there when whatever the alleged incident happened?
The alleged incident took place at her grandmother's house and my father's house.
Okay, but you were not personally
I
involved
was
in
not
that?
present there.
Okay, you were not present there where it allegedly happened.
No, I was not present where it really happened.
And did you tell the defendant multiple times that you didn't have anything to do with this?
I told her I have nothing to do with this and I'm not getting her in contact with my sister.
So not only did you tell her you didn't have anything to do with it, you told her,
I'm not involved in this.
did she listen to you after you told her that?
No,
How do you know she didn't listen to you?
because I told her that in the first aisle number 7, and then she's coming back wanting to deal with it again in aisle 38. I took it as a complete wash and 7 that this was a done deal, that I was not involved and was not getting involved.
Yes, ma'am, and you made that clear.
Yes, sir.
Now, you mentioned earlier that, y'all, between when you were on aisle 7 and 38, when you were under cross, by Mr. Wright, that you all had passed each other like ships in the night
Correct.
between the time when you first saw her on aisle 7 and aisle 38.
Correct.
So y'all had passed each other like ships in the
Yes,
night?
sir.
Okay. Did she pass you at the time preceding this, did she pass you like a ship in the night that time?
No,
What did she do at that time?
no, this time she's stopping to tell me, hey, are you on the phone? So I need to talk to her.
Now, if she would have passed you the second time like a ship in the night, would you have stopped to engage with her?
No,
Why not?
my conversation with her had ended on aisle 7. It's complete.
So do you believe that had she not stopped, or had she passed you like a ship in the night this time, that fight wouldn't occur?
Correct.
Mr. Wright, on cross, when he asked you, he said, she deployed her hands only. And you responded that that was correct. She only deployed her hands.
Yes, don't use her hands.
Would it surprise you if I told you that the defendant is a trained combat veteran?
If your honor, she's facts, not evidence. He's testified in 6 facts, not evidence.
Well,
It's in evidence.
objection overruled some video.
Oh, okay, all right, I do get that.
Yes, I was aware she was in the military.
So when she deployed her hands, can we agree that was combat hands?
Yes, correct. She's military trained to defend and protect all domestic and foreign terrorists.
No further questions.
No more questions, Your Honor.
Okay, may this witness be excused?
Yes, Your Honor.
Okay, Ms. Lee, you may be excused. You can step down and we have a blessed day.
All right, she asked if she could stay, is that admissible? We have no further witnesses to call with.
The rules have not been invoked.
I'll motion that, you know.
Okay. And so the rule has been invoked. Ms. Lee, you have to, remain outside of the courtroom and only come back into the courtroom if, you are instructed to come back into the courtroom by the court. You cannot talk to any witnesses about your case or your testimony. You'll be allowed to talk to the lawyers. Okay, you have a blessed day. Okay, your next witness,
Your Honor, at this time, the state rests.
defense.
I would call this one there again.
Okay, Ms. Miller, would you please come forward? Ms. Bailey, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may put your hand down, Ms. Bailey. You may take the witness stand, you can adjust the seat and the microphone. Mr. Kimber?
Madam President, Your Honor.
Yes, you may.
Barry, I'm handing to you what's been marked as Defense Exhibit 1. Does that fairly and accurately represent the object that Ms. Lee struck you with in the altercation?
Yes, sir.
Shall we retender defense 1 as demonstrative evidence?
Say,
Yes, Your Honor, state will avoid our witness at this time.
okay, you may.
Mrs. Bailey. Do you know how long this candle is?
No, sir.
Do you know the thickness of this glass in this candle?
No, sir.
So it's not possible for you to determine whether this candle fairly and accurately represents the candle you were hit with on the day in HEB.
No, sir, I don't remember.
But you don't know the thickness of the glass, you don't know how long this candle is.
I don't know the specific dimensions, no, sir.
Do you know range?
No, sir, but I remember seeing those Catholic candles, those religious candles.
So you saw some religious candles.
I remember seeing them and being struck with it.
What other kind of candles were on the counter on the shelf that day?
I don't recall.
Could you identify this candle for us in the video if we play it?
No, sir, the video's pretty far.
Video's
Well,
pretty.
like, when you're watching, it's pretty far.
But you testified earlier, you're not sure about the dimensions on this candle,
Not the dimensions, no, sir.
nor are you familiar with the dimensions of the candle that you were hit with the day at HEB.
I'm not familiar with the dimensions, but I do remember seeing those have distinct like pictures and characters.
Okay, so you're saying that the picture was the same.
No, similar.
Okay, and you don't know what gauge, how do you know that the thickness of the glass on this candle is the same as the thickness of the glass in the other candle?
I don't know, sir.
So you don't know, okay. The state at this time objects to the admission of this as a improper, insufficient predicate.
Obviously, she's not under the exact specifications or dimensions of the object, Your Honor. That's not what's required. It just has to fairly and accurately represent as demonstrative evidence what she was struck with. I believe that's what she's testified to. And she has personal knowledge of that because she was.
Objection overruled. Okay.
All right.
Defense exhibit number 1 is admitted.
Before this incident at HEB, when was the last time you'd seen Madrika Lee?
It
had been a couple of years ago. She was living at my grandmother and grandfather's home. And my son was a few years smaller at the time.
And would he stay with your grandmother and grandfather? Would he stay, would your son stay at your grandmother and grandfather's house or not?
Yes, sir, we would visit often.
Okay, and when you visited your grandmother and grandfather's house with your son, I guess to pick him up or drop him off, was Madrika Lee there?
Yes, sir, she lived there at the time.
So you were familiar with her, you knew who she was, she knew who you was, is that right?
Yes.
And did you know if she knew your son or was familiar with her son?
Yes, sir, we used to go with my grandmother to take her to work.
To take Madrika Lee to work?
To take Madrika Lee to work, yes, sir.
Where was she working?
She was working at the high school in Port Arthur.
Memorial?
She was a substitute.
Is that-
Memorial.
Okay. I think everyone here can infer that there was some sort of, I don't necessarily say animosity, but tension perhaps existed between you and Ms. Lee or the family. Is that right?
There was tension in the family because of the marriage, but not me and her personally.
Okay. Was there a particular incident that had occurred with your son? What is his name, by the way?
Levi,
Levi, between Levi and Anita's two oldest children, Max and Madeline.
yes, sir.
Just without going into detail, just to kind of contextualize it, what is alleged to have occurred? What happened?
During the kids' winter break from school, Levi, Madeline, and Max were spending time at my grandparents' home. And there was an alleged sexual something that occurred
Between the children?
between the children.
Objection,
My
Your Honor.
parents here.
Okay.
Objection, it's out, she wasn't there, she didn't witness any of this, it's hearsay, it's irrelevant.
She said alleged, it's being offered to contextualize this whole incident between her.
Objection sustained. Okay, go ahead and move on.
When you attempted to speak with Madrika Lee initially in HEB, was it regarding what you had identified as this alleged incident, regarding that incident?
I didn't attempt to speak to her about the specific situation.
Okay,
I had asked about had she heard from her sister, and I just told her I was trying to get in touch with her.
and why were you trying to get in touch with, I guess Anita, is that right?
Anita, yes.
Why were you trying to get in touch with Anita?
Because of the situation with the children, so we could talk as parents, but I didn't go into detail with Madrika Lee.
About what you thought had occurred, is that right? Had you attempted to contact Anita before? Had you been successful?
So,
Had you attempted to contact Anita through your grandparents?
yes,
And had you had any success in getting any kind of contact with Anita to resolve this incident that allegedly happened between the kids?
no, sir.
Was it causing you some concern, or what were your concerns at that point about what had happened?
Yes, sir, I was concerned because the situation had not been solved and no one was trying to give actual answers. None of the parties were trying to give actual answers.
You reported that to the authorities, that you got involved, got law enforcement involved, or CPS, or anybody involved in that investigation to investigate?
Not at the time I wasn't able to,
Why not?
because I wasn't able to get any information any further information.
Were you relying on what Levi had told you, or what were you relying on?
No, my grandparents had told me,
Okay, so it wasn't just Levi making the allegation, your grandparents had told you?
not just Levi. Levi spoke, but the adults spoke to me first, my grandparents.
Right. So what was the result of your initial contact with Ms. Lee?
In the store.
Yes, ma'am. And I'm gonna limit it to everything just in the store, that what happened after the initial, or what was the initial contact? What happened?
You're saying when we first seen each
When you
other?
first saw each other, you asked, did you get in touch with Anita? I mean, what happened?
Well, when we first seen each other in the store, we were on the spice rack, and we recognized each other, and I just was like, oh hey, can no, have you heard from your sister? I have been trying to get in touch with her. But at that time, she did say that she doesn't want to talk about all of this. She did know what had happened. And then she went into a long rant about what was going on in the family. And that is why we talked for so long, or we were in that aisle for so long.
What was the nature of that discussion?
Was the nature?
Yeah, what were you talking about, what, in that first contact in the spice aisle?
Well, she just was telling me about how she felt about like my grandmother and her father being married, and that there were feelings, there were issues between, her sisters and mother, and between like my grandmother and the family. And she stated that I was younger at the time, so I didn't know all of that, but I just informed her that they don't have anything to do with me. I just was just trying to get in touch with her sister, because it's going.
So you didn't discuss with her the alleged incident, right?
No, I didn't say anything specific to her.
But from your understanding, she appeared to be aware of it?
Yes, sir, I know she's been aware of it.
Objection, Your Honor, they had no idea what's going on in someone else's mind.
I asked what her understanding was.
Hold on a minute. So what's your objection?
I'm objecting because it's outside the scope of her personal knowledge, and otherwise, it's predicated upon something else that's hearsay, therefore.
I agree.
Objection Sustained.
I agreed with, I asked her what her understanding was, not somebody else.
You go-
What's she going on?
Raise your question.
So you parted ways from the spice rack without any animosity, is that right, or? But, and how many times would you say that you passed her throughout the store after that first contact before we see what occurred there on aisle 38?
Each other a couple of times.
But just any words exchanged, or just like she said, ships in the night, passing each other? How was the?
So it wasn't any issue.
Were you following her, stalking her, or anything like that in that you did?
No, sir, for the most part, we would be coming from different directions.
So like passing like this?
Yes, sir.
Let the record reflect I'm moving my hand right to left.
Record was so reflect.
All right, so what happened on aisle 38 to make you approach her again?
Oh, nothing made me approach her. I was getting ready to go check out.
Okay, so you were, and again, aisle 38, is that on one end of the store, like towards one end of the store, or is it more towards the middle of the store?
That's a middle aisle. Like it's an aisle that leads out to, depending on what direction you're going, it's an aisle that either leads to the checkout area or it leads to the back of the store.
So were you proceeding down aisle 38 to go check out?
Yes, sir.
And again, Ms. Lee is on that aisle, right?
Yes, sir.
So why did you stop to talk to her? Why didn't you just go by her, go past her?
I was still walking. I was slower, like once we were passing, but I was still walking. I was always going to the checkout.
What happened to make you stop? Why did you stop walking towards the checkout?
Um, I was leaving. We both were on the phone, but I was leaving, and I was just like, hey, once again, like if you can get in touch with your sister, or if you're talking to her, please let her know that I've been trying to get in touch with her. I just want to talk to her.
Reiterating it to,
Yeah.
okay, can we go ahead and play? I guess. So it's your test, you were leaving the store and this would be the last time you see her, and were you just reiterating, hey, if you see your sister, tell her to.
So,
Okay, yeah, just play it if you would, thank you. But here, your testimony, you're telling her, hey, let me tell her to get in touch with me, or what are you telling her, talking to her right there?
Yeah. So I was just, once again, I was just, letting her know, hey, if you get in touch with your sister, or if you're talking to her, please let her know that I've just been trying to get in touch with
She
her.
appears to hold her phone out to you. What is she saying to you there?
Um,
Stop it.
so, at that point, she was saying, like, she got a little snappy, and she was saying, like, that she's not on the phone with her sister, and she did reiterate that she's not gonna talk to her sister, but then she was holding up the phone, and she was, like, forcefully trying to tell me that her mother wanted to talk to me. She was trying to make me talk to her mother.
And did she say anything else to you at that point?
Yes, so she put the phone on speaker and her mother's yelling and she's, reiterating about the sister and she doesn't wanna talk about the sister. And I had said, well, we do have to talk about it, like as parents, we should really get to the bottom of it because, you know, it's, it was brought to my attention that Madeline and Max had touched my son and there was a video involved. And at that point, she stated to me, verbatim, she said, well, your son's a nasty ass bastard.
Okay. And did you call Madeline or Max any names?
No, sir.
Did you perceive her to move towards you before you moved towards her?
Yes, sir. It felt like she was always moving toward me with the phone and the things that she was saying.
Did you perceive her to step towards you? When she stepped towards you?
Yes, sir.
Did you feel that to be a threat? Did you take that as a threat to your physical safety?
Yes, sir. A lot was going on, the yelling and all of that, the phone.
A lot of high tension,
Yes, sir.
different than the first encounter or the same?
Yes, sir.
Different.
Different than the first encounter.
When she stepped towards you, would you say that was in an aggressive manner when she stepped towards you? Is that the way you perceived it?
Yes, sir.
And again, you felt that you were threatened when she did that?
Yes, sir, I did.
And did you do what you did in response to that perceived threat to your physical safety?
Yes, sir, in the statement. Yes, sir.
And what did you do?
I poked her. I pointed my fingers and I poked her
Did you make physical contact with her when you pointed at her?
unintentionally.
And where did you make contact with her?
Her forehead.
And was it, in your opinion, was it enough to cause somebody physical pain?
No, sir. No, sir.
So when you made physical contact with her, it's your opinion that it wasn't sufficient to cause physical pain, is that correct?
No, sir.
That is your opinion, is what I mean.
That is my opinion.
Right. That when you made contact with her, it didn't cause her pain.
No, sir.
Objection, Your Honor. I would ask for instruction that the jury disregard that she doesn't know whether the victim was still in pain.
I asked her opinion, not that whether she actually was or not, just whether she thought it was sufficient to cause physical pain. She's aware of this. She has personal knowledge of how hard the poke was, so I'm asking her, based upon her knowledge, her personal knowledge of how hard it was, whether in her opinion that was sufficient. to
Okay,
cause
objection
pain.
sustained. Jury will be instructed to disregard, the answer. We may move on.
Did you intend to cause her physical pain?
No, sir, never.
What did she do in response to you when you pointed at her? Okay,
She grabbed my hand. She grabbed my arm.
okay.
Sorry.
And was she maintaining control of your wrist?
Yes.
Wouldn't let go?
Yes, sir.
Okay. Did you try to get your wrist back?
Yes, sir.
And let's be clear, you've been in the military, right? What
Yes.
branch of service were you in?
I was in the army.
Okay, how far did you get in the army?
I spent exactly a year in the army.
Okay, you went through basic training,
Yes, sir.
and then what did you do after basic training?
I went to AIT, which is where we learn our job, what our job is gonna be in the military.
And what was your job in the military?
I was a power generator mechanic.
Okay. You learned how to work on generators?
I did, yes,
I
sir.
need to keep you on speed dial. So you didn't have any kind of specialized combat training or anything beyond what you get in basic training?
No, sir.
What did you get in basic training regarding hand-to-hand combat?
We-
Anything?
We didn't. We didn't learn hand-to-hand combat in the basic training.
Do they teach you how to shoot a rifle, or what did they teach you?
Yes, they taught us how to shoot rifle.
But not how to engage hand to hand with somebody?
No, sir.
So you don't have any combat training, hand-to-hand combat training?
No, sir.
Any specialized knowledge of fighting or anything like that? Any martial arts training or anything like that?
No, sir. I've never been in a fighting too.
And that was your first fight?
Yes, sir.
So it's your testimony that she was holding your wrist, is that correct?
Yes, sir.
And you couldn't get your wrist back?
Yes, sir.
And did you try, or what did you do? What were you doing when she had your wrist controlled?
I told her to let me go.
And then, let's go ahead and keep playing. Holding you there. What are y'all talking now?
I just asked her to let me go. Well, I told her to let me go, but we just were standing
Would
there.
you agree with me, once she has control of your wrist, the next aggressive move comes from her, not you, is that right?
Yes, sir. She raised up her hand, the hand her phone initially was in. She raised up her hand and she did.
Let's go back, can we rewind that? Yeah, just not all the way, but just when she's just got her, oh, I'm sorry, I'm trying to. Yeah, right here, all right. All right, so right here, talking, she got the phone out. Poker, right? And you she got your hand pinned. Let's get, keep playing, I'm sorry. And you're talking, right? So she makes the first move on you there, right?
Yes, sir. She raises up her hand and she punches me in my head.
Oh, and then that caused you pain.
Yes, sir, it did.
And let's just keep playing if we can, Sarah, thank you. And we see y'all fighting, and both of you are fighting, right?
Yes, sir.
She gets you down, throws you down. You get up. Pulling each other's hair, right? Pulling each other's hair.
Yes, sir.
Y'all saying anything to each other?
No, sir. I don't recall us speaking at all.
Okay. And she gets you down. Got you trapped. Would you agree right there you're pinned?
Yes, sir.
She throws a punch when you're pinned, right?
Yes, sir.
You agree that looks like neutral combat to you?
Objection, Your Honor, leading.
Does that look like neutral combat to you?
Yeah,
It looks,
objection sustained.
Is it to leading, Your Honor? Can I rephrase? To leading?
Yes, you may.
Does that appear to be mutual combat to you?
yes, sir. We're having a fight.
That's right there. She's got the candle, right? We see it and she's hitting your leg. Is that correct?
At that frame, yes, she's hit my leg and she hit all of that left side of my body, including my head.
And that would have been including your head?
Yes, sir.
And that would have been with a candle the same or similar to this defense exhibit one,
Yes, sir.
right? Go ahead. Permission to publish, Your Honor?
Thank you.
So you got whacked with that candle a few times, right?
Yes, sir.
In the head,
Yes,
did it hurt?
yes, sir.
How bad did it hurt?
It hurt extremely. I was hit when I hit it in my neck and on my left side of my body, my leg, my thighs.
Can I approach, Your Honor?
Yes, you may.
Bailey, I'm handing you what's been marked defendant's exhibit 2. In this corner, it has another defendant's exhibit here, which I'll ask you about. Does that fairly accurately depict the condition of your thigh at or near the time of the altercation?
Yes, sir.
Call for defense to
No objection,
Okay, dismiss exhibit number 2 is admitted.
Ms. Bailey, I notice this has another defense exhibit up here in the left corner, our exhibit's in the right corner. Where does that other exhibit number, where does that derive from?
We, last summer around this time, we had a civil suit, the Draco League, filed a civil suit against me on the last day.
Okay, can you use the same picture in the civil suit? And in
Yes.
the civil suit, did it have that exhibit number or that exhibit sticker on?
Yes, sir.
What other injuries did you have as a result of the glass encased candle being deployed against you besides your thigh? You said your head, did you have any blasting concussive effects from being hit in the head with the candle?
A patch of my hair was ripped out, after I had like nausea and dizzy spells. And I had nausea, dizzy spells. I was having trouble using the restroom and stuff. From my memory, yes. And I went to the hospital for it.
Okay. You were contacted by the police, law enforcement after this happened? I mean, you gave a statement initially, right, to the police there?
Yes, sir. I was called and asked to come give a statement.
And you voluntarily went down and gave a statement, correct?
Yes, sir.
In an attempt to cooperate, correct?
Yes, sir. I was just told that it was to wrap up, what was going on at HEB.
At all times, during this incident, were you acting when what you believed to be self-defense?
Yes, sir. Miss Madrigal Lee is 2 to 3 times bigger than me. I'm barely 100 pounds. Yes, sir. I was scared.
Okay, and all the actions that you took, did you take those actions because you believed them to be reasonably necessary?
objection, Your Honor, leading witness.
Objection sustained.
Did you take those measures because you reasonably believed they were necessary to defend yourself, to protect yourself?
Yes, sir. I felt like she was gonna hurt me. She fell on me a few times as well. So, yes, sir.
Absolutely.
Mr. Burke.
How are you now? I'm well, thank you for asking. You had mentioned, on your direct testimony that you, never received any hand-to-hand combat training. That's your statement? Are you sure about that? Well, I've got a copy in my hand of a Go Army website where it says week 3
You
to
actually
4.
got it, that's not evidence, Sean.
Are you familiar with,
Objection sustained.
are you familiar with the Go Army website?
Yes, sir.
And you attended basic training?
Yes.
And would it surprise you to know that
Objections, not evidence, Sean.
I can impeach her if she lied about, made a mess for, or I can impeach and search for the truth.
Go ahead.
I
Okay,
can,
you may, your objection overruled. You may proceed.
would it surprise you to say, would it surprise you if I said to you that there are marketing material from with the Army that says that every person that goes through boot camp receives hand-to-hand combat training?
Can you repeat the question?
Sure. Would it surprise you to know that there is Army advertising material that says people that are enlisted in the Army receive hand-to-hand combat training?
Again, Your Honor, I would object that that's outside evidence, it hasn't been introduced, it's not in evidence, it's improper impeachment.
Objection overruled.
Please answer the question.
It wouldn't surprise me, no.
Why wouldn't it surprise you?
I believe that is a common, I would think that's a common thought from a civilian perspective, yes, sir.
So this is marketing material from the United States government. Does this in a civilian perspective, it's a fact.
You said that it's marketing material?
From the United States Army, yes. So I'm asking you, is it surprising to you? Not from a civilian perspective, I'm not asking from a civilian perspective, I'm asking from your perspective. Is it surprising that there's information out there that says, if you're enlisted, you go through boot camp. Boot camp contains hand-to-hand combat training.
No, sir, I'm not surprised that that is marketing.
Okay, I'll move on. You said earlier that, this meeting here, this was mutual combat.
We were having a fight in HEB.
Well, would you be surprised to hear that, Officer Wills testified earlier that mutual combat requires consent between parties?
Objection as far as the legal conclusion, it's not binding on the jury.
Your sustained.
Are you aware that mutual combat requires consent from both parties?
Again, I'm gonna object, that's not part of the law, Your Honor.
It was stated, it's on the record, it's testimony on the record, and the record.
It may be what the officer testified to, but that doesn't mean that that's it to the law.
Well, that's a finding of fact that's up to the jurors to decide.
I'm just saying it's being represented that that's what the law is, and that's not
I never said it's what the law said, I said
What it
it was
requires.
Officer Wills' testimony.
what it requires, as far as what the officer required. There's no legal requirement.
Our objection will sustain. You can rephrase your question.
Are you familiar with the elements that are required to be met for mutual combat to be applicable?
Repeat it for me one more time.
Do you know what it takes for mutual combat to apply to this situation?
No, sir, I've never heard of that law before, and until I was informed about it at the HEB, scene I was told to.
So you have no idea what it takes to qualify as mutual combat?
No, sir, I would have no reason to.
Then why would you testify earlier that it was mutual combat?
I said that we were having a fight in HEB.
So you're saying you never said it was mutual combat?
I said that we were having a fight in HEB.
Right, but I'm asking you, did you say earlier that this was mutual combat?
I agree.
You
that
agree?
We were having a fight in HEB.
Right. I'm asking you a question, yes or no question. Did you say, yes or no, that this was mutual combat when your attorney asked you whether it was mutual combat? Yes or no? Okay, so you said it was mutual combat. Okay, but you have no idea what it means to have mutual combat.
No, sir.
Then why would you say that you were having mutual combat?
From my understanding, what I was told and what I heard from the testimony with the officer, I understand it to be mutual combat. We were having a fight in HEB.
So you're saying now you heard from the police officer there was mutual combat?
I listened to the testimony that the officer gave.
So you're saying that there was testimony that said this was mutual combat? So you're saying that there was testimony in this courtroom that was mutual combat?
I listened to the officer's testimony when she described mutual combat.
Right. And did you hear her say that was mutual combat? Is that your testimony?
I heard her describe what mutual combat was.
Okay.
But before today, before that incident, I had no recollection of that law.
How does she describe mutual combat?
How did she describe it?
Sure. You just said you heard her say it. How did she, and that's how you learn mutual combat. How did you know how did she describe mutual combat?
From my memory of the first day of court, she described like the definition, the exact law, and I can't repeat that from memory back to you. But I did listen.
Okay, so she said that mutual combat requires consent between parties, and she stated this was not mutual combat. That's what she said. But you're here saying right now, I want to make sure I got your testimony locked in. You're saying that Officer Wills stated that this was mutual combat.
From what she described, she gave the definition
She gave the definition. What was that definition?
I just said I can't repeat what she said today. By verbatim,
Get as close as you can, please.
can't repeat it.
We're gonna move forward. So you said here on this video that you thought when it was your testimony that you felt Miss Lee was a threat to you when she stepped forward. Is that correct?
Yes, sir. This is what was happening.
Farrah, can you rewind that? All right, pause it right there. So let me ask you, when something's threatening you, how do you react to a threat?
When something's threatening.
Mm-hmm.
It depends on the situation.
Well,
What is the threatening situation?
I'm just asking, how do you typically respond to a threat?
Different threats arise. There's all kinds of different
Okay,
threats.
well, we got a threat. You thought that was a threat?
Yes, due to what was happening, what she was saying, when she was snapping and yelling at me, and her mother snapping and yelling at her, moving toward me, yeah.
And so instead of de-escalating, you just decided to step forward and punch her in the face or knock her in the face with your hand.
Can you repeat that question?
When you said you felt a threat, and you felt that by her showing you a phone, which you came and approached her, right?
By her showing me a phone, no, sir.
I'm talking when y'all first met, how you approached her, correct?
Repeat the question.
When y'all on this aisle 38, you approached her, correct?
In passing,
But you approached her, correct?
I spoke to her in passing.
Okay. And she steps forward and shows you her phone because you were inquiring from her, right? You testified, it was your testimony earlier that you had asked her a question.
And I just was speaking to her.
Okay. And you felt right here, I'm not asking you about anything else. You felt, but you said you felt afraid when she stepped forward. Okay, that's what you said. That was your statement, right? You felt afraid when she stepped forward, right?
Along with
I'm
her speaking to me and the her mother yelling at me.
okay. And you went forward and you said earlier that you poked her.
I did say that earlier.
You want to change that statement now?
No, sir. That was
Okay. Farrah, will you please press play so we can take a look at the poke? Pause it. You testified earlier, she's a big woman. She's about twice your weight, right?
Yes, sir.
But we can agree you poked her, struck her with your hand hard enough to push her back into that aisle.
Unintentionally.
Unintentionally. So how hard do you intend to poke her?
I didn't intend to harm her.
I didn't ask you, how hard did you intend to poke her?
I didn't intend to harm her or even poke her.
You didn't intend to poke her.
I didn't intend to harm her.
That's not what you just said. You said you didn't intend to poke her.
I didn't intend to.
Okay. But you actually poked her hard enough with your hand, struck her with your hand hard enough to rock her head and her whole body back. A woman that weighs twice to 3 times as much as your weight. Is that correct?
Yes, sir.
Okay. So you took your hand and you made physical contact with her face hard enough to knock her back into the shelf. Is that correct?
Unintentionally.
I'm not asking you if it was intentionally because the law allows conviction with recklessness. You understand that?
Yes, sir.
Okay. So whether you intentionally acted or not, recklessness is enough. You understand that?
Yes.
So what you did was put your hand and you launched forward and you made contact with her face hard enough to knock her into that shelf. Do you understand that? Is that correct?
Repeat the question. Please.
When you took your hand, you stepped forward and you pushed it into her face, it was hard enough to knock a woman back into the shelf.
Yes, sir, that is what happened. In
Okay.
real time, that is
Okay,
what happened.
okay, that, yes,
What's going on?
we agree, that's what happened.
Yes, sir.
And we can also agree that if you strike her that hard to knock her back, it's logical that that could result in pain.
Her objection calls for speculation.
I,
I think I asked her on the rec whether it was her opinion what she calls her pain, and there was objection to that. So I'm gonna object to that calls for speculation.
Objection sustained.
all right, we're gonna change gears here. Now, let me ask you, Miss Bailey. Do you believe the laws of this country apply to you?
They apply to everyone.
And we can also agree that generally speaking, it would be wrong to walk up to someone and do that.
Generally speaking.
Okay, so generally speaking, we can agree that it's wrong to walk up to someone and do it. Can we agree to that?
Generally speaking. Okay.
How old were you on 4/16/2023?
Was 26. 26.
26? And do you know how old Mrs. Lee was at that time?
40.
40s? Would it have mattered to you then if you knew that Miss Lee was twice your age and suffered from scoliosis when you did that?
But then, as far as the scoliosis, the sport, there's no evidence in the record of that. She was subject to direct, and that wasn't elicited.
Objection sustained.
I'm saying, would it have mattered to you knowing that Mrs. Lee was almost twice your age when you walked up and did that to her? Would it matter to you back then?
Would it have mattered to me? I mean, I have no knowledge of.
Would it have changed anything for you?
Would it have changed anything for me?
Mhm.
Well, our situation doesn't have anything to do with our medical issues. I'm a disabled veteran as well.
I didn't ask you that. I'm asking you, would it have changed anything? Knowing what you know now from this proceeding, would it have changed anything? Would it cause you to change anything about your actions that day?
I don't, I don't understand how that's relevant.
That's not your job to object. Your job is to answer the question. So I'm gonna ask you to answer the question.
I don't know. I don't know. I don't know her personal or medical situation.
So no regrets.
Sir?
No regrets from that day.
Yes, I do have regrets from that day. Yes, sir.
What regrets do you have?
I have regrets from that day that we even ended up in that situation. Our, up until that moment, our conversations with each other were just fine. We don't have any personal
I'm not asking
anything.
Wait, Larry, that answer?
And she's going outside the scope of the question.
The objection would be non-responsive.
So, non-responsive, thank you, right?
Objection sustained.
Non-responsive, so I ask you to answer. Like,
Well, yes, sir. Also, I do, yeah, I regret that we were even in that situation. I do regret unintentionally poking her and, being flustered by the statement that she made.
So,
Yes, I do have those regrets. I've never been in a fight a day in my life, and I'm not an violent person. So, yes, sir, I regret this entire situation.
so you regret taking your hand and putting it against her face as hard as you did to knock her against that wall. Do we agree to that?
Yes, sir, I regret poking her. Yes, sir, I do.
And you regret knocking her against that shelf.
Yes, sir, I didn't intentionally do anything.
I told you the law allows a conviction for recklessness.
I'm understanding.
Okay. Now, I've got to ask this question. So, you were in the military, right?
Yes, sir, I will.
Fair, if you could play that video. So when you were here and you're holding her like that, And then, do you recall when she fell down, you started wailing on her, we all kind of binding together, you were wailing on her like this, do you recall that?
I'm sorry, repeat the question one.
Do you recall when she went down to the ground, you were over her, you're punching her, do you recall that? Okay, so my question for you is, did you use your military combat training to beat Mrs. Lee that day?
As I stated earlier, I don't have any military combat training.
And that, if you want to take that, if you want to keep that statement, I believe the ladies and gentlemen of the jury have common sense. But I'm asking you, did you rely on your training to beat her that day? Yes, that's a yes or no question.
That is a no, I don't have any military combat training. I understand that that is a common misconception, from the civilian
Ma'am,
standpoint, but that is.
You're being unresponsive right now. I'm just asking you, I'm not asking you a narrative. We'll get to your, to these things later, but I'm asking you, did you rely on your training? Because you had to ask.
I think she answered, she doesn't have any training, your hours can ask that.
Section on, you can ask the question. Section on blue.
Did you rely on your military training to beat Mrs. Lee that day?
No, sir, because I don't have.
It's a yes or no question, ma'am. It's a yes or no
You
question.
answer the question. Her answer, she doesn't have, he's presupposing that she has training and asking her if she uses it. Her answer is, I don't have any training, therefore I didn't use
I will
it.
move
That's the
forward.
answer.
I'll move forward.
Okay, he's moving forward.
In your interview with Detective Hancock, where you went in and sat down and had a talk with them, do you recall that interview? You told Detective Hancock that Miss Lee struck you first. You recall that statement?
Yes, sir.
Do you stick by that statement today after watching this video?
Miss Madrigal did hit me first.
So you're she hit you first.
She raised her hand up.
Fair, can you rewind that bit? I don't think we're all on the same page here. I don't know if you, okay, right there. Rewind it 10 seconds. Okay, play it. Pause that. You just pause it, sir. So I want to make sure we're clear. You're telling the ladies and gentlemen of the jury right now that Miss Lee hit you first, despite what we're looking at right now.
Miss Madrigal did raise her hand and she hit me
That,
first.
that is, I'm asking you strictly, did she hit you first? Are you sticking to that statement?
She did. Mhm.
Okay. I'm asking, did she hit you first?
She did hit me first.
During your interview with Detective Hancock, you also said that you were about to check out before you went down that aisle.
Yes, sir.
Can we agree that if you didn't go down that aisle, this fight would have never happened?
Yes, sir.
But you went down that aisle.
Yes, sir.
After Mrs. Lee told you she didn't want to talk about it anymore.
I had no idea that she was on that island.
Not asking you that, you went down that aisle after Mrs. Lee told you she didn't want to talk about it anymore. Is that correct?
I so happened to have went down.
I'm not asking about that, ma'am. I'm simply asking you, you went down that aisle to talk with her after she told you she didn't want to talk to you anymore. Is that correct?
I didn't go down that aisle to talk with her.
I'm not asking why you went down that aisle. This is simple.
Well,
Did
that's
you
what
go
said.
down? I'm asking you, did you go down that aisle when you didn't have to? After she already told you she didn't want to talk anymore. It's a yes or no question.
I didn't know that she was down that aisle. I randomly went down an aisle. I didn't pursue her.
Mrs. Bailey, don't you want to tell the ladies and gentlemen of the jury the truth?
Yes, sir, and I have.
Then tell them. You went down that aisle even after Miss Lee told you.
Yeah, she argued.
It's not argumentative. I'm simply asking her a question that she has yet to answer.
Objection overruled. Mercy.
Did you go down the aisle after Mrs. Lee told you she didn't want to talk about it anymore?
I went down the aisle unknowing that she was on that island. I was going home to check out.
I'll move on. Now, you want the ladies and gentlemen of the jury to believe you were defending yourself, is that correct?
Yes, sir.
But we can agree that you stepped forward and put your hand in Mrs. Lee's face hard enough to knock her back first, before she ever touched you, correct?
I did poke her inside.
Before she ever touched you, correct?
Yes, sir. I feel threatened.
I didn't ask you that. She never touched you, and you put your hand in her face. Is that right?
For my hand
And she had never touched you.
at that point.
Okay. And you're asking ladies and gentlemen of the jury to believe that you were defending yourself. That's true.
Yes, sir. These are the things that they were doing.
Now I wanna at the end of the video here, when you're down, Farrah, will you play it and skip towards the end of the fight? Yeah, right there. Pause it, please. What position is Miss Lee in right now?
She was,
She trying to fight you back?
we were having.
I'm not asking, is she trying to fight you back?
Yes, sir.
On her hands and knees with her face down with her hands covering her head, you think she's fighting you back?
Yes, sir. We have been fighting the entire time.
You punched her about 5 or 6 times over the snippet we just watched, correct?
I wasn't counting.
We can rewind it so we can count. Please, rewind a few minutes. 1. You can pause it right there. How many times was that?
I didn't count.
Well, I did. Would it be fair to say it was about 15 or 16 times?
I didn't count.
Did you see how many times she tried to punch you back?
She did.
Ma'am,
She didn't.
does that mean she didn't try to punch you back? Right there?
No, I'm saying that during the video, she didn't.
Okay, she didn't do what?
She didn't hit me back.
Okay.
She was on-
But you hear about 15, 16 times.
Didn't count.
Okay, I did. It was about 16-0. And you call that is that self-defense to you?
Well, yes, sir. I've been hit with items.
So you're asking ladies and gentlemen of the jury to believe that you could punch somebody 16 times and a person not punch you back a single time, and you were defending yourself. I'm just asking a yes or no question. Okay, that's enough. I'm not asking you
So I would
to
never object to that vote of interrogation. She's entitled to answer the question. The objection not responsible to make it.
The question was yes or no.
Sustained. Objection sustained, man.
Mrs. Bailey, if you don't mind, if I ask you a question that merits a yes or no response, will you please restrict your questions to yes or no?
And I would object, she can answer the question she sees fit. If she doesn't like it, he can object non-responsive and the court can rule on it. She can answer how she sees fit to answer the question.
Okay, objection over. May proceed.
Now, play that, Farrah. Something I want. Play it. You play right here. All right, stop it right there. What was that? What was that you did? What was that you kicked with your foot?
Oh, I don't know.
You don't know what it was
It
you
was
kicked?
scattered on the floor, I don't know.
Barry, can you rewind that? Who'd you kick that towards?
I just kicked the item out of my way.
Right, but who'd you kick? Who did you kick it toward?
I just kicked the item out of my way.
Which way did it slide? Who did it slide to? Who did it hit?
The item slid toward his leg.
It slid toward me. Did you see it make contact with it slid?
No, sir, I just kicked.
Barry,
the
you can
item out
rewind
of
it,
my way.
and we can look at it and make sure. You need to come around and have a look. You're welcome to do that. You see that?
Yes, sir.
Okay. Did you see it hit Miss Lee's backside?
No, sir, not even in that moment. I just kicked the.
I'll ask you in a
item out of my
moment,
way.
did you see it hit Miss Lee's backside in this video?
No, sir.
You didn't see that.
No, sir. It was on the floor and the lady was on.
Right, but the only one you kicked was the like cell phone there. That's the only one you kicked, and you kicked towards Miss Lee. You could have kicked it in the other direction, you could have just stepped over it and got out of there. Why did you choose to kick that?
I didn't, I just kicked the item out of my way. There was things scattered on the floor.
Now we're gonna move on to your medical here. You said that you sustained a bruise.
Among other injuries, yes, sir.
And did you go to the hospital after that fight?
I did go to the hospital.
How long did it take you to go to the hospital after the fight?
I think, I don't recall. It was the other day, so I don't recall. It was 3 years ago.
So do you not recall? Or is it within a day or so?
It was within a couple of days.
What day? When you went to the hospital, what did you tell, and what did you tell the doctor was wrong?
I don't specifically remember what I told the doctor. I told him I was in an altercation, an assault or something, which they misread as a sexual assault or something.
So it's your statement today that you went to the doctor and you told them that you were in some kind, they misread, they misunderstood what you were saying and recorded it as a sexual assault.
They attempted to, I had to correct them.
So they attempted to record it as a sexual assault, but then you corrected the doctor because they didn't know what they were doing.
No, that's not what I said.
Okay. Well, I have a copy of your medical report here.
Your Honor, again, I want to object, this isn't an evidence, they're gonna try to impeach, this is improper mode of impeachment of the record.
I'll rephrase, John.
Okay, objection sustained.
Would it surprise you? Would you be shocked to know?
Object to the ballot skipping as well, if it's subpoenaed records, if she's being impeached with private medical records, it's knowledge.
She admitted she already gave medical records, is that right?
She hasn't provided, we haven't provided any medical records. I think there's a privacy concern with her medical records. I mean, if it plus we're on Zoom, I mean,
Objection sustained.
YouTube.
Did you give your medical records to the police officer?
I don't recall giving the medical records. It was 3 years ago. I do recall getting like those pictures, but I don't recall giving my medical records.
So you reported to the police officers that you sustained diarrhea as a result of getting hit with the candle.
Yes, among other injuries.
Now, we're gonna talk about that. Earlier that you said that you had made you so upset. In your interview with the Officer Hancock, you You said you were upset this time during all, when you were at GB, is that correct?
Due to statements we made, yes,
So you were upset,
yes, my feelings was hurt,
your feelings were hurt,
yeah.
and she made that statement to you before you knocked her in the face, is that correct?
Before I approached her, yeah.
And so that statement upset you,
My God, yes,
okay, very much,
yes, because what happened with the children
okay.
and my baby.
So you were upset when you knocked her in the face,
I was upset when I approached her inside.
okay. You also said, you were upset about the stuff with the kids, some video or something that might have been out there, or familial dispute. You were upset about that, where nobody was giving answers.
No, I said I was upset about the statement that she made regarding, because of what was going on with kids, regarding kids.
Right.
Specifically my son,
Mm-hmm.
the victim.
He was a victim,
Yes, sir.
right? And you were upset about what was going on, or did it not matter to you?
No, yes, it did.
So you took it seriously.
I wanted to know as a parent, yes, 3 children were involved.
And you never filed a police report.
I wasn't able to, no, sir.
You weren't able to. Were you out of the country?
No, sir.
You just didn't do
No, sir, I wasn't able to.
it. Okay. Um. So you're saying you were, let's see here. No further questions at this time.
Okay, Mr. Calvin.
Briefly, right now, I want to rewind this because of the very exception. I want to log the bad horse here, but. There, I get it, there.
Am I allowed to have my water or no?
Give up water.
Yeah, just in the initial, when they. On aisle 38, just see the,
The initial
on the 30, when they're on the aisle 38. He steps forward to you, and then you react, correct me, freeze it. She didn't. Freeze it. You would agree with me that she didn't make contact with you first, is that right?
Not physically, but
But physically, right? She didn't make, you made first physical contact, correct?
yes, I
Was that in response to your perception of the apparent danger that she was exhibiting towards you when she stepped forward, your physical response? So she may not have made the first, she didn't physically touch you first, but did you feel an apparent danger from her actions moving towards you when you physically touched her?
Objection, Your Honor, he's leading the witness.
It's a question.
Objection sustained.
It's,
This direct examination can't lead on to that.
were you reacting to a perception of apparent danger when you touched her? Apparent danger. We can keep going. Yeah, sorry. I'm not gonna play the whole thing. I just want to. And to be clear, you didn't hit her, is that right? I'm sorry. You didn't hit her, is that correct?
no.
Okay. I freeze it right there. Right here, is she trapping your arm?
Yes, sir, she has my arm.
Are you trying to do anything else to her at this point? Keep going. Tells you to have your arm, then she hits you, right? She hits you first. Pass it.
No further question, John, with states.
Okay, ladies, witness, we step down?
Yes, sir.
Okay, Miss Billy may step down.
I anticipate resting. I'll have to make a motion.
You may be seated.
I anticipate resting. I do want to make one motion.
Okay, ladies and gentlemen of the jury, we're gonna ask that you step outside the courtroom. Follow the bill. If everyone please stand as the jury exits the courtroom. Anthony,
She's got to go to the restroom.
go to bed recess.
Yeah. She put well within the time and so on state. 600. A lot of people know how to do it. There's a lot of ways to do it.
State, are you ready?
Yes, Your Honor, state ready.
Defense, are you ready?
Ready.
Ms. Bailiff, would you please bring the jury into the courtroom? And everyone, please stand as the jury enters the courtroom. You may be seated. Jefferson County Court, Law number 2 is back in session and calls number 23 CCCR 0744. Case is style of State of Texas versus Kiana LaShawn Bailey. Let the record reflect that Ms. Bailey is present in court with her attorney, Attorney Wright Kimmer. State is present with Assistant Criminal District Attorney's Attorney Fred Vernon and Attorney Farrah Nixon. Let the record also reflect that the jury is now present and seated in the courtroom. At this time, ladies and gentlemen of the jury, I will read to you the court's charge containing the law applicable to this case. Members of the jury, the defendant, Kiana LaShawn Bailey, stands charged by information with the offense of assault causing bodily injury, alleged to have been committed in Jefferson County, Texas, on or about the 16th day of April of 2023. To this charge, the defendant has entered a plea of not guilty. I now give you the law that applies to this case. Our law provides that a person commits the offense of assault if the person intentionally, knowingly, or recklessly caused bodily injury to another. So that you may better understand the nature of the offense with which the defendant is charged, I now define certain terms and words. The term bodily injury means physical pain, illness, or any impairment of physical condition. A person acts intentionally or with intent with respect to a result of her conduct when it is her conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of her conduct when she is aware that the conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to the result of her conduct when she is aware of but consciously disregards a substantial or unjustified risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. Oral interview statement. You are instructed that unless you believe from the evidence beyond a reasonable doubt that the alleged statement introduced into evidence was freely and voluntarily made by the defendant, or if you have reasonable doubt thereof, you shall not consider such alleged statement for any purpose nor evidence obtained as a result thereof. Therefore, if you believe from the evidence beyond a reasonable doubt that the defendant, Kiana LaShawn Bailey, did in Jefferson County, Texas, on or about the 16th day of April of 2023, did then and there intentionally, knowingly, or recklessly cause bodily injury to Madrika Marie Lee, hereafter styled the complainant, by striking her about the face with her hand, causing pain to the victim, you must next consider self-defense. Self-defense. A person's use of force against another that constitutes the crime of assault causes bodily injury is justified by self-defense when the person reasonably believed the degree of force used was immediately necessary to protect the person against the other's use of force or attempted use of unlawful force. Self-defense does not cover conduct in response to verbal provocation alone. The defendant must have reason to believe the person or the other person had done more than verbally provoked the defendant. Burden of proof. The defendant is not required to prove self-defense. Rather, the state must prove beyond a reasonable doubt that self-defense does not apply to the defendant's conduct. Definition: reasonable belief. Reasonable belief means a belief that an ordinary and prudent person would have held in the same circumstances as the defendant. Application of the law to the facts. To decide the issue of self-defense, you must determine whether the state has proved beyond a reasonable doubt that either the defendant did not believe her use of force was immediately necessary to protect herself against Marie Lee use or attempted use of unlawful force, or number two, the defendant believed her use of force was immediately necessary to protect herself, but the defendant's belief was not reasonable. You must all agree that the state has proved beyond a reasonable doubt either element 1 or 2 listed above. You need not agree on which of these elements the state has proved. If you find that the state has failed to prove beyond a reasonable doubt either element 1 or 2 listed above, you must find the defendant not guilty. If you agree that the state has proved beyond a reasonable doubt each of the elements of the offense of assault caused bodily injury, and you all agree that the state has proved beyond a reasonable doubt either element 1 or 2 listed above, you must find the defendant guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in her presence. If any question develops during your deliberations, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced into evidence, nor legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you in the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror, nor consider it yourself in arriving at a verdict. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. The last page of the charge is the verdict form. The verdict form has two parts. It has a top and a bottom. The top states, "We, the jury, find the defendant not guilty as charged in the information of assault causing or causes bodily injury." If that is your verdict, then your foreperson will sign on the top line. Or at the bottom it states, "We, the jury, find the defendant guilty as charged in the information of assault causes bodily injury." If that is your verdict, then your foreperson will sign on the bottom line. Okay? Does everyone understand? Okay. State, are you ready?
Yes, Your Honor, stage ready.
Defense, are you ready?
Ready. Oh, we're ready, Your Honor.
And both parties agreed on 15 minutes, is that correct?
Yes, Your Honor.
Okay. State, you have the right to open and close. You like to open or reserve your right?
Your Honor, the state would like to have 8 minutes.
You gonna split it up?
Yes, sir, split it up.
Okay.
7 minutes to begin.
We can read 16 to make it even again.
Thank you.
16 minutes, 8 and 8?
Mine's 16.
Okay. You may go forward. So it'll be 16 minutes each side. Okay. And I'm keeping time.
May it please, Your Honor.
Yes, you may proceed.
Ladies and gentlemen of the jury, I know it's been a long day, but I do thank you for your time. I understand that you sacrificed your family, sacrificed your work, sacrificed time and things that you've been doing. Thank you for executing on the civil duty. Thank you for your time and attention. On behalf of myself, for Nixon, and the community of justice. over the course of the trial, I truly enjoyed, getting to know you all over the process, and I understand here in the jury pool, we've got some of the safety workers, we've got some of the structural workers, and then some of the teachers. And, you know, I understand that how important they do this, and thank you again for being here today. And if you recall, over the course of the trial, you send the judge, call balls and strikes. You saw myself and the defense go back and forth a little bit, but that's how our system works, and that's what justice requires. But you also observe, you know, we felt Mr. Nixon take on our burdens, and we're gonna gladly release foreign that force today. You also saw us present you with truth. You've also saw us attempt to draw some lies and expose them to best we could. And my hope is that we've given you everything that you need to drive comfortably through that green light. Comfortably, knowing beyond a reasonable doubt that you can find Ms. Kiana Bailey guilty of assault. Now I'm going to describe for you the roles of the defense. The defense attorney's job in general, they are paid to challenge evidence. And you saw the course of this trial, you saw Mr. Wright Kimler, you saw him challenging evidence that we presented. You saw him probing. That's his job. However, over that time when there's probing, defense attorney's probing, they deployed some tactics. And I want to caution you about that. One of those tactics are, they'll take what should be a clear, cut, and dry case, such as what is displayed right there on the television for you. And they will attempt to muddy the water, attempt to hide the ball, shift it around a little bit. You observe some of that over the course of the trial. Secondly, raise that doubt, seed that doubt, and pour a little water on it. Want that doubt to grow. But I'm here to ask you, keep your eye on the ball. Keep your eye on the facts. The defendant is guilty because he took her hand, made a connection with the face of Mrs. Lee, and knocked her back into that shelf before Mrs. Lee ever touched her. Thirdly, defense attorneys typically tend to raise issues that distract you from the facts, that elevate what your eyes have seen, what your hearts have felt, what your minds have perceived. One distraction. For example, here, you saw us raising issues about this here candidate. What does that have to do with whether Mrs. Bailey took her hand and knocked Mrs. Lee in the face? Nothing. Nothing to do with that. That's a distracting tactic. Call it the candidacy. Don't let it distract your mind. You ask yourself, when the defendant took her hand, knocked Mrs. Lee back, what does that have to do with the elements of the charge? Knowingly or recklessly caused bodily injury to Mrs. Lee when she put her hand in Mrs. Lee's face and knocked her back into the shelf. While Mrs. Lee was just shopping, she was working, trying to feed her family. Her son, you heard her testify, he's autistic, he lives with her. Her grandmother lives with her. She's the breadwinner, she works, she takes on jobs. Then she's going back to get her education. Her baby boy's getting his education. But Miss Bailey comes along and wants to end all that. Don't let her get away with that. Set a better standard for our community. Set the standard that we will not tolerate that type of behavior. We have a duty to be the safeguard and the check in the system. I'm going to frame the issue for you that you should keep your eye on as you go back there and deliberate. Real simple. And the facts are straightforward. Mrs. Bailey, knowingly, intentionally, and or recklessly, only need to prove one of them. But she told you, she admitted that, hey, I intended to poke her. Okay, you intended her hand to strike her face and knock her back, okay? And that's clear, but even more still, recklessly. You heard the jury instructions from your honor. Recklessly, she didn't care about everything. If you read those jury instructions, you'll see it. The elements of recklessness are met as well. Choose either one and proceed forward to striking. caused her hand to strike. We saw the video. She admitted to striking her. She admitted to putting her hand right there in her face and knocking her head back. This is clear, cut and dry, and we're passing the baton on to you to finish the duty of safeguarding our community. The elements are met. You saw the photos. You saw the photos. Now, Ms. Bailey can take that stand all she wants to and say, oh, well, I didn't mean to cause pain. There wasn't no pain that possibly. Get serious. She knocked, now, be honest, Ms. Lee's a big woman. And Ms. Bailey's a small one. But she used enough force to knock her head back into that shelf, and there's no question there was pain. Thought he was told, right? The blood goes in between the skin and the bone, right? That there's a scratch on her eye. There's a busted lip. That there's scratches on her hand. So any statement or testimony given up there saying, I'm hurt. Bunch of hogwash. And if she wasn't hurting then, I guarantee you she was hurt after she wailed on her 16 times and the victim didn't throw a punch back except for that one when she got a good knock on her in the face when she was holding her back there. 16-0. That's not self-defense. That's called assault. It's called bodily injury. And in a few moments, the fence will come and talk to you. And he's gonna do three things. First, he's gonna talk about,
7 minutes.
he's gonna talk about the candlestick. He's gonna do the candlestick trick to take her out the ball. He's then gonna get up here and talk about, my words are not evidence. Well, I agree, my words are not evidence, but they are truth, and you can take them to the bank. And next he'll say, oh, let's talk about a little bit about self-defense. But
At 7:45.
if Mrs. Bailey didn't follow her, there would be no fight. No follow, no fight. No follow, no fight. Self-defense is off the table. Next, let's look at common sense.
8 minutes.
He's not gonna discuss with you common sense. He's not gonna tell you. He wants you to doubt that. You use your common sense. When you took an oath, and you became a drawer, one of those obligations wasn't to leave your common sense at the door. You bring that right back on in here with you, and you use it back there while you're in that deliberation box. In such, I encourage you to trust your gut, feel the truth, trust your eye. Don't fall for the candlestick trick, and don't allow the tactics of the defense to deceive.
That's 8 minutes and 36 seconds. Okay, defense.
Thank you, Your Honor. Very much confident the prosecution, closing argument. Just for the record, I don't get paid on every case I take. I heard free sometimes, when I think it's necessary. So yeah, I do get paid to represent people, but I do things for free. I think it's necessary to uphold justice. And that's what your duty is. It's not your duty to return a verdict. It's not your duty to be the last link in law enforcement, any of that type of thing. The judge is instructed in there that your duty to see that justice is done. And I would suggest to you that you go back and vote your reasons in the common sense, or anything. To be the correct result in this case, you do that individually, that's your duty to see that justice is done. What I mean by that is you can't come to a verdict, you can't agree, it's not a collective responsibility to see that justice is done, it's just, you can't agree, so we have a hung jury, you can't agree, and the case comes back for another jury to listen. So, having said that, I only have 16 minutes, so I'm gonna stick to that, we're holding to that strictly, so I'm gonna move, kind of fast in here. It's important that the judge's instruction, anything that the lawyers say in this case is not evidence, it's not that's binding on you. The law, it's necessary to decide the case, all of it is contained in the court's charge to you, that's what control. You'll notice that there's no mention of equal combat in here. It's not a legal concept that's going to be determined in this case. It doesn't matter what I think the law is, what mutual combat is, what Mr. Vernon thinks, what Officer Wilkes thinks, or even what Justice of the Peace Doyle downstairs in her the civil case in this matter, what she thinks. It's what you all evaluate the evidence to be, given the confines and the constrictions imposed on you by the terms of the court. So, having said that, also, I would just make some observations about the evidence. I'm not going to belabor it. It appears from Mr. Vernon's, at least his opening half of the argument to you, that the state is concentrating on perhaps the first portion of this altercation. And again, I think there's kind of a dividing line. If you look at the video, and again, you're free to evaluate it however you see. This is just how I view it. You have the first part of the altercation where we see the defendant approach and make the motion towards Ms. Lee, and makes contact with her, pokes her as it's been described. And that's one aspect of this assault case, right? The first part of this, and then there's kind of a line you can draw, a bifurcation between that. And then the subsequent fight that we see where Lee is holding Ms. Bailey's hand and then punches her, throws the first punch, his actual punch, and then it continues on from there. So you have two different factual aspects, or two different factual portions of this. The first portion, the state is arguing, well, the poke caused physical pain because her head went back and hit the shelf. That's an assault. Well, we've raised the issue of self-defense, and it applies to both portions of this altercation, both the first, and I would say the subsequent aspect, and they're required to disprove that beyond a reasonable doubt, which may seem kind of exceptionally difficult, but we don't have to prove to you that she was acting, so we raise the issue, now it becomes Mr. Vernon's burden to convince you beyond a reasonable doubt that she was not acting in it. So if you again look at the video, you'll see before Ms. Bailey steps forward and pokes her, Ms. Lee makes a motion, steps forward, right? You can see it. Maybe a small step, but she makes a step towards her, her hands extended with the phone. The court's instruction to self-defense is not only use or attempted use of unlawful force from somebody else. It's not, you don't have to wait to be hit first for you to be acting in self-defense. It's the other person's, your perception of the other person's attempted use of force against you. That's what controls in self-defense. So it's not the actual use of force where you have to actually be hit for be self-defense. It's your perception of the other person's attempted use of force against you. That's judged from the standpoint of the person who's claiming self-defense, whether it was reasonable from their perspective, from a reasonable person's standpoint, the actions that they took. So looking at the first portion of this, Ms. Bailey, again, she's there in a heated conversation. We can infer that from the circumstances of this. And Ms. Lee makes this, what I would characterize as an assertive and aggressive movement towards her, holding the phone, keeping in mind that there's an ongoing heated conversation going on. Ms. Bailey's perception of that was an attempted use of force against her, so she reacts by poking her. And then we see Ms. Lee grab her hand, and I guess they're continuing to discuss things, and Ms. Lee attacks Ms. Bailey, punches her. And from there on, from after the punch is thrown, you could infer that Ms. Bailey is acting in self-defense. She's the one who got punched from that point on. And again, it's not our burden to show you beyond a reasonable doubt she was acting in self-defense. You have to believe beyond a reasonable doubt that she was not acting. So that's what Judge Holmes has instructed you here on the third page, where he's talking about where you have to, imposing the idea of proof beyond a reasonable doubt, where you have to disbelieve beyond a reasonable doubt either one of these two before you can. So if you have a reasonable doubt, if he hasn't convinced you beyond a reasonable doubt of the self-defense, then the verdict's not done. And again, it's looking at both portions of this altercation. The first part, it seems, is a different circumstance where the argument is there was physical pain when she poked him. You may not even believe beyond a reasonable doubt that caused physical pain, right? Bodily injury, and I'm getting physical pain from the court's definition of bodily injury. Bodily injury is the same as you make contact with somebody that causes physical pain, then that's an assault. So if you think it was just a poke and it didn't cause physical pain, you don't believe beyond a beyond a reasonable doubt that the vote caused physical pain, then it's not guilty in and of itself, irrespective of self-defense. But obviously, after the punch was found and the fight ensued, I'm sure Ms. Lee felt physical pain from the punches and everything else. But again, that's a different aspect and a different application, so that's from that portion of I commend the case to you. You can go back and you've already seen the video numerous times. I'm sure everything I say, you're gonna go back and look at it, draw your own conclusions. Which as you should, that's the way it should be. I'm sure you'll do the right thing. Just keep in mind that your decision is constrained by the court's instructions and the legal parameters that he's instructed you on. And again, particularly the law of self-defense and this idea of proof beyond a reasonable doubt, which is so important. And we hear us talking about it all the time. It's not defined. You're not going to see it. There's no definition in here about it. I think he tells you, as in every charge, it's not proof beyond all possible doubt. Again, as we just discussed in Ward R, you're going to go back and you're going to have to come with your own minds about how difficult of a burden that is. I would just suggest to you that obviously a result of conviction in and of itself is bad enough to be convicted of a criminal offense, class A misdemeanor assault. The conviction itself is punishment, but the possibility of even losing your freedom for up to a year in jail is a potential consequence of finding that burden to be met. So it's not an impossible burden, but that's just, I would say, contextualizes how high the burden proof beyond a reasonable doubt is because of the potential consequences of deprivation of freedom. And it's not all possible doubt, but I would suggest to you again that it's a very high burden. That you all will consider that, consider the consequences of evaluating the state's case. I would suggest to you that there is reasonable doubt in this case, especially about self-defense, that the state has not established beyond a reasonable doubt that Ms. Bailey was not acting in self-defense. And so that the appropriate verdict should be not guilty. Thank you.
Okay. Mr. Vernon, you have 7 minutes and 24 seconds left.
Ladies and gentlemen of the jury, this will be the last time that I speak with you here in this courtroom. And first, I'd like to address some references made by the defense. First one is that misdemeanors punishable amount to a year in jail. That's true. Don't let that make you feel bad while you're going back there. You know why? Because it's the defendant's own actions that brought her before you. You didn't do anything. Do that. All you're doing is executing your oath, applying the law and the facts. The defendant's actions cause her to be where she is. So you both confident, you will arrive at the right decision. Next, defense mentioned that this is not, that your function is not a collective process. Well, you all know now that in our Constitution, the man that drafted it wanted a dictatorship of a king. And they didn't trust all that power in the hands of one man. So they assigned a unanimous jury to find guilt. So it's a collective activity in contrast to what the defense said. It takes a collection, all 6 of you voting together to find justice, not one individual. You all are greater than a single sum. I also want to be specific here. In your jury charge, it said strike with the hand. That said punch, didn't say any of that. A strike with the hand. Knowing, intentionally struck with the hand. If that's what we saw, don't take your eyes off the ball. Next, he raises the issue about self-defense. Well, your jury charge says it must be immediately necessary. Self-defense to qualify must be immediately necessary. You will get to watch the video again back there in deliberation. And I'm sorry, but if this is immediately necessary as a threat when someone shows you a cell phone, people can walk around here beating people up all day. That's not the example or the standard that we want to set. So a vote for not guilty says if someone walks towards you with their cell phone and raises their tone a little bit or whatnot, you can punch them in the face and that's self-defense. My God have mercy. That's not the standard we want to set for our community. It's not an aggressive move forward. You don't get to follow someone around in HEB and then walk behind them after they told you we don't want to talk, and then bully them, and then claim self-defense. You don't get to go and beat someone up well over 16 times and then claim that self-defense. The law doesn't work like that. No one's above the law. And I ask you to apply the law when you go back there and deliberate. So in closing, as the judge gives you your jury charge, I myself, on behalf of the community, I also charge you to do justice. The law empowers you to do justice. And justice demands that you find the defendant guilty of assault in Jefferson County on April 16, 2022.
Okay, ladies and gentlemen, for the jury, before you go into the jury room to deliberate, I must inform you that one person on the jury is an alternate, and the alternate is not allowed to go into the jury room to deliberate with the other jurors. The alternate will be available if one of the jurors is not able to continue deliberations. And the alternate in this case is Cynthia Ann Odell. Who is that? Miss Odell? Okay. So Miss Odell, you're the alternate in this case. You could either sit out in the hall or in the gallery as the jury deliberates. Okay, that's your choice. So at this time, I'm going to hand the charge and the verdict form to the bailiff. Ladies and gentlemen of the jury, you can stand, follow the bailiff into the jury room. Court will be in recess until the jury returns with a verdict. Court will be in recess. And Ms. Okay. Let me know when you're ready. You ready? Okay. Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 23CCCR 0744, case of style of state of Texas versus Kiana LaShawn Bailey. Let the record reflect that Ms. Bailey is present in court with her attorney Wright Kimler. State is present with Assistant Criminal District Attorneys, Attorney Fred Vernon and Attorney Farrah Nixon. Let the record reflect that the jury is not present in the courtroom. I have received a message from the jury that it has reached the verdict. Will the bailiff please bring the jury into the courtroom? Everyone please stand as the jury enters into the courtroom. Just hold on to that. You may be seated. Jefferson County Court at Law number 2 is back in session and calls number 23CCCR 0744, case of style of state of Texas versus Kiana LaShawn Bailey. Let the record reflect that the attorney for the state, the attorney for the defendant, and all members of the jury are present and seated in the courtroom. Foreperson, have you reached a verdict in this case? Okay. Is the verdict unanimous? That is one that is agreed upon by all jurors.
Yes.
Okay. Would you please hand the verdict to the bailiff to be delivered to me? Okay. That goes there. Foreperson, is the verdict the unanimous verdict of all members of the jury?
Yes, sir.
Okay, you may be seated. Ms. Bailey, would you please stand with your attorney? We, the jury, find the defendant guilty as charged in the information of assault causes bodily injury. And Mr. Kimler, you like that jury poll? State, like that jury poll?
No.
Okay. Here you go. Okay, ladies and members of the jury, first of all, on behalf of the citizens of Jefferson County, behalf here of staff in County Court at Law number 2, I'd like to thank you for your time and attention that you have given in this case. I know that this was not an easy case, and I know that you were very attentive because I watched you the past couple of days. Now, your jury service has concluded. You can return those badges. And as I mentioned to the members of the panel, those individuals who were not fortunate enough to be a part of this jury, I told them that, you know, anytime that they're in the area of County Court at Law number 3, they can have a seat in the courtroom. I'll extend that to you as well. Anytime that you're in the area of County Court at Law number 2 of Jefferson County, Texas, you can have a seat in your courtroom. And as I mentioned to you earlier, it's your courtroom because I'm only an humble public servant serving the citizens of Jefferson County. This court belongs to the citizens of Jefferson County. You are the citizens of Jefferson County. So you can have a seat in your courtroom anytime that you would like to come and visit with us. Now, as I mentioned to them, and I'll mention to you, you can have a seat in that area behind that wall that we call the bar. You can sit in that area. We call it the peanut gallery, but you can't bring peanuts in here and eat because this is not the Texas Roadhouse. But you can have a seat in your courtroom, and I'm sure you'll find it very interesting. Now, the lawyers may want to talk to you about your verdict. You can talk to them if you choose to. If you choose not to, that's your right. So you do not have to talk to them if you do not want to talk to them. The bailiff, she has some letters that she's going to give to each and every one of you. If you would like to drop us a line, please feel free to drop us a line. And before you leave, I need to give each and every one of you a handshake. I know we still have COVID in our community, so I'll give each and every one of you what I call an air handshake. Thanking you for coming down here today and thanking you for making sure that justice is done in this case. So at this time, if you need any excuses, we have our court administrator. She can provide you with an excuse because our our district clerk's office is closed at this time. So again, ladies and gentlemen of the jury, thank you for being with us. Each and every one of you have a blessed day, and you are excused. Jefferson County Court, Alert number 2 is back in session. The court is in session and calls number 23 CCCR 0744. Case the style of state of Texas versus Kiana LaShawn Bailey. Let the record reflect that Ms. Bailey is present in court with her attorney, Wright Kimler. State is present with Assistant Criminal District Attorney, Attorney Fred Berner, and Attorney Farrah Nixon. The court has just concluded the guilt and innocence phase of this case. Is there an agreement or anything regarding punishment?
I know.
Okay, so the court, it all depends. Do you like to do?
Get a PSA, I guess.
Okay, so we're gonna order a pre-sentence investigation report, commonly referred to as a PSI. We usually give the probation department about 30 days to order the PSI, then we will reconvene on this case to do the punishment once we get the pre-sentence investigation report from the probation department, okay? So at this time, Ms. Gavner? So this case is going to be reset for pre-sentence investigation report. Our court administrator is going to give you a court date. Once she gives you the court date, you'll be free to go. Yes. Okay.
She's gonna tell you.
Give us a,
Yeah. All right. She's gonna tell you what you need to do.
yeah, just reset it.
Yes.
Huh? Yeah, you have to give it a deadline. Yeah.
Oh, Braylon.
What date is that?
Monday. It came Monday.
I put the 23rd. That's
The 22nd, 22nd.
Get the other lady too.
Oh.
Okay, this case will be reset for the 23rd of July for sentencing.